proceeding with judgment today. This matter has enjoyed a lot of publicity. It is important to remind myself about my oath of office and role in this trial. My role as a judge is to look at the facts objectively, dispassionately, and to apply the laws of our country and judge the accused accordingly. Judging is not a popularity contest. Judges must have thick skins and should not be swayed by people who have not been trained in this noble profession and who knows absolutely nothing about it. I am required to divorce my personal views and not be swayed by public sentiments and emotions, which at times might be fickle and changes. Every person who appears before you must have the confidence that he or she will get a fair trial, no matter who or what they are and what deeds they had committed. The role of this court is to dispense justice. One should also divorce one's religious persuasion, no matter what it is. Satanism, which is not a criminal offense in our country, is not on trial, but the evil deeds that were committed by the accused and have been found guilty of are heinous, barbaric, and cold-blooded crimes in terms of the laws of our country. On 3rd June 2019, after a marathon trial that lasted 37 days, I convicted accused 1 of 22 counts, which included racketeering and 7 counts of murder. Accused 2 was convicted of all 32 counts that were preferred against her. This included the count of racketeering, managing an enterprise, and 11 counts of murder. Accused 3 was convicted of 21 counts, which included racketeering and 8 counts of murder. There are a number of purposes to the sentencing task of the court. The first is to visit punishment or hardship on the offender. It is intended to make life unpleasant as possible for that offender. It is a form of retribution visited by an aggrieved community upon people who wreak havoc or harm upon that community. A second purpose of sentencing is that of individual deterrence. This can be achieved in a number of ways, most usually in cases of violent crimes such as these, by locking a person up in order that they are not free to again offend, in order to protect members of the community from such people. A further purpose of sentencing is that of general deterrence. Other persons who might be tempted to offend, whether to commit crimes such as murder and robbery, should learn that crimes do not pay, and that there is a response to such crimes which also makes crimes not worth it. In short, the intention is that the potential offenders will weigh up, on the one hand, the possibility of personal enrichment or personal satisfaction, and on the other hand, the probabilities of apprehension and severe punishment. It is hoped that in this way, potential offenders will be deterred from committing offences. The final purpose of sentencing is that there is the prospect of rehabilitation. It is intended, although not always achieved, that the sentence which is imposed may assist an offender in turning away from crime. It is for this reason that we have a number of different types of sentences, ranging from community service through to suspended sentences or fines or imprisonment itself. In determining an appropriate sentence, which is a sentence which is fair and just, one must have regard to the crimes which have been committed, the personal circumstances of the people who have committed those crimes, and the interests of the community, in particular in this case, the interests of the Groenewald, Burger, Bonsaier, Bendixen, Meyer, Jackson, Schofield, Schroeder, Mcalpin, McGregor, and Lateran families, and in general, the Pretoria, Krugersdorp and surrounding communities, and the South African community at large. The accused were legally represented, were warned at the onset of the proceedings about the minimum sentences that are applicable if they were found guilty. Traditionally, our courts have had an unlimited discretion about the imposition of sentences in cases of murder, rape and robbery. However, as a result of considerable community concerns, the Criminal Law Amendment Act 105 of 1997, and in brackets the CLAA, was passed. It imposes certain mandatory minimum sentences. The murder counts that the accused have been convicted of attracts minimum imprisonment of life in terms of Section 51(1) of the CLAA, provided that the court is, in terms of Section 51(3)(a), satisfied that substantial and compelling circumstances exist which justify the imposition of a lesser sentence than the sentence prescribed in those subsections. In terms of Section 51(2), the minimum sentence that is applicable for the aggravated robbery counts is 15 years imprisonment. unless there are substantial and compelling circumstances existing which would justify a lesser sentence than the prescribed one. The same applies for count 19, which is for fraud, since the fraud involved an amount of more than 500,000 rands, which attracts a minimum sentence of 15 years imprisonment, unless there are substantial and compelling circumstances existing. Count 31 also attracts the minimum sentence of 15 years imprisonment. Section 3.1 of the Prevention of Organized Crime Act 121 of 1998, and in brackets POCA, states that any person convicted of an offence referred to in Section 2.1 shall be liable to a fine not exceeding 1,000 million rands, or to imprisonment for a period of up to imprisonment for life. This is applicable to both counts 1 and 2. Accused 1 therefore faces a potential of 8 life imprisonment sentences. Accused 2, 13 potential life imprisonment sentences. And accused 3, 9 potential life imprisonment sentences for some of the offences that they were convicted of, if I were to find that there are no substantial and compelling circumstances present in terms of the CLAA. However, since accused 3 was 14 years old in relation to the 2 murders that she was convicted of, Section 51.6 of the CLAA prevents her from being sentenced to life imprisonment for those murders. She therefore faces a potential of 7 life imprisonment sentences. The accused, who called themselves Electus Pedeus, had embarked on a reign of terror from 4th July 2012 to 30 May 2016, which ended after they were arrested in June and July 2016, respectively. Accused 2 was the mastermind of the group, which had unleashed a past of destruction that destroyed and ruined so many lives. It is almost that the Krugersdorp area and its surrounds were struck by a man-made tsunami, the only difference being that this tsunami had chosen its victims carefully, and before striking had scouted and ran trial rounds on its victims. The driving force of this tsunami was accused number 2, who, unlike the forces of nature, had directed when and where the tsunami had to strike. During that reign of terror by the accused and other co-accused, they had believed that they were committing all of the crimes on the pretext that the murders were justified to safeguard the orphans from attacks from the satanic witches and money that were needed to continue to fund the said orphanages. They were all led to believe by accused number 2 that some of the murders were biblical and therefore justifiable, and were committed to prevent accused 2 from going back to the satanic church. Our beloved country is faced with a high crime rate. We live in a violent society where the sanctity of life is not respected. All members of our society are vulnerable and are in the firing line of murderers and robbers. It is the role of this court to dispense justice. There are 11 deceased who were brutally murdered in this matter, namely Natasha Berger, 33 years old, Joy Bonsayer, 63 years old, Reginald Bendixen, 75 years old, Michaela Valentine, 23 years old, Peter Meyer, 51 years old, John Meyer, 47 years old, Jared Jackson, 44 years old, Glenn McGregor, 57 years old, Anthony Schofield, 60 years old, Kevin Mcalpin, 29 years old, and Johanna Lattergan, 52 years old. They were all innocent and murdered in a brutal manner and simply did not deserve to die the way they did. Natasha and Joy were murdered on the 26th of July 2012 at their residence at Landslet Complex, Widow Park, by accused 1 and Michaela. Natasha was stabbed 17 times and died of multiple stab-incised wounds to her neck. Joy was stabbed 6 times and died of stab-incised wounds to her neck. On 13 August 2012, Bendixen was murdered at his house by accused 1, 3, and Miranda, and had sustained 9 stab wounds and a fracture of the skull, which caused his death. On 4th October 2012, Michaela, the wife of accused 1, was murdered by Miranda and accused 3, after she had informed various people, including her husband, accused number 1, that she wanted to be out of the group. She had taken part in the 3 aforesaid murders. She had sustained 15 size penetrating wounds and a blunt force trauma to the head, which was the cause of her death. Joshua Groenewald was supposed to be the next murder victim in 2013, but the plans to murder him were scuppered after Jake Staviliers had left the group. After a lull of about 2.5 years, accused 2 had set a new goal for the group, and it instructed them to seek new income by robbing and murdering persons whom they had perceived to be wealthy. This led to the murder and robbery of Peter and Joan Meyer at their home on 27 November 2015, and only 6,600 rands had been robbed from them. They were murdered by Miranda, accused 1 and 3. Joan had sustained 24 stab wounds, which caused her death. Whilst Joan was being murdered in front of her husband, Peter, with his hands tied behind his back, he recited Psalm 23, which read as follows, and I quote, "The Lord is my shepherd, I shall not want. He makes me lie down in green pastures. He leads me beside still waters. He restores my soul. He leads me in paths of righteousness for his name's sake. Even though I walk through the valley of the shadow of death, I will fear no evil, for you are with me. Your rod and your staff, they comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil. My cup overflows. Surely goodness and mercy shall follow me all the days of my life, and I shall dwell in the house of the Lord forever." The Afrikaans version reads as follows, "Die Here is my herder, niks sal my ontbreek nie. Hy laat my neerlê in groen weivelde. Na waters waar rus is, lei hy my heen. Hy verkoop my siel. Hy lei my in die spore van geregtigheid om sy naam ontwil. Al gaan ek ook in 'n dal van doodskade weer, ek sal geen onheil vrees nie, want U is met my. U stok en U staf, die vertroos my. U berei die tafel voor my aangesig teenoor my teenstanders. U maak my hoof vet met olie, my beker loop oor. Met goedheid en guns sal my volg al die dae van my lewe, en ek sal in die huis van die Here bly, 'n lengte van dae." Close quotation. The recital of Psalm 23 had no effect on the murderers, who had all professed to be Christians. Peter was thereafter stabbed 15 times and died of multiple penetrating incisive wounds. Thereafter, an elaborate plan was put in place to obtain more money, resulting in accused one faking his death. Accused one had made accused two the beneficiary of his life policy for 3.57 million. On 16 December 2015, Jared was traveling with accused one, and Leroux Steyn, to Peter Steyn, was first given a juice laced with sleeping tablets, strangled, and was placed in the accused one's SLK Mercedes-Benz, and his body was set on fire whilst he was sitting on the driver's side of the vehicle. Accused one went into hiding on the pretext that he had died in his SLK vehicle and had assumed the identity of Jakes de Villiers. An insurance claim was lodged with Discovery, which was not paid out after the police had suspected foul play. More victims who were assumed to be wealthy were identified by the group, since more money was needed by accused two to allegedly sustain the non-existing orphanage and for her health. This led to the murders of 4 more people. The first being Clan Kit McGregor, who was murdered on 26 January 2016. He was shot twice by Marinda, who was accompanied by Barnett, Leroux, and accused number 3. 6,000 rand was transferred from his account into Marinda's account. 3 other persons who were murdered on separate dates at 17 Kosana Flat by Marinda, Leroux, Barnett, and accused number 3. The same modus operandi was followed. The first person, Robert Anthony Schofield, was murdered on 10 May 2016, and 16,600 rands were stolen from his account. The second person, Kevin Victor Mcalpin, was murdered on 26 May 2016, and 1,300 rands were stolen from his account. The third person, Johanna Lattegan, was murdered on 30 May 2016, and 3,000 rand was stolen from her account. During the killings at 17 Kosana Flat, accused 3 and Barnett would wait in Barnett's room, and once accused 3 was given the cards and PIN numbers of the deceased, she would be accompanied by Barnett to an ATM to verify the correctness of the PIN. Once the PIN code was correct, accused 3 would then phone Marinda, who would instruct Leroux to proceed to murder the victims. They all died of ligature strangulation. A total of 27,500 rands was obtained from the 6 murdered persons. Accused 1 did not testify in mitigation of sentence, but had called Annette Vergeer as his witness. She is a probation officer employed at the Department of Social Development in Krugersdorp. She has 34 years of experience. She prepared a psychological and pre-sentence report, which was read into the record and handed in as Exhibit 5Ts, which she also confirmed as correct. It is not necessary to repeat the contents of the report in any great detail, save for what is relevant for purposes of sentencing. She had consulted with accused 1, his parents, and was given a copy of the judgment on conviction. Accused 1, who is a first offender, was born on 3rd August 1985 and is 34 years old. After he matriculated, he enrolled at the University of Potchefstroom, where he completed the BCom degree in actuarial science and had obtained a distinction in mathematics. After completing his degree, he went to live abroad in London for 1 year and managed to work whilst touring abroad. He then returned to South Africa and accepted the position at Absa as a financial advisor. He also worked at Discovery as a financial advisor and worked for 3 years until May/June 2015. Whilst working at those companies, he was earning an above-average salary of approximately 70,000 rands per month. He then started his own forex trading company called Untitled Trading. At the time of his arrest, he was self-employed. He has been in custody since his arrest in June 2016, which is approximately 3 years and 2 months. He got married to Michaela Valentine in 2010 and was married to her for a period of almost 2 years, when she was subsequently murdered. They did not have any children. He was a well-adjusted, happily married, earning an above-average income, educated and relatively young man who was a practicing Christian believer. His whole life took a turn for the worst after becoming involved in the Overcomers Through Christ and meeting with Accused 2 and Miranda. The initial crimes in 2012 were committed due to Accused 2 wanting to take revenge on Ria and her manipulating the accused into believing that those crimes had to be committed for a greater good. That is, to protect Accused 2 from satanic attacks and to protect and provide for the orphan children. This would include that his wife, Michaela, had to be eliminated as she had become a threat to the existence of the group. He was drained financially by Accused number 2, who was a manager of the enterprise. During 2015 to 2016, Accused 2's constant cash flow had drastically decreased, and she needed her foot soldiers to proceed in committing crimes, thus the Mayers as well as Jared Jackson. Accused 1 was brainwashed into committing the crimes. He is a family-orientated and believed that he was used and hypnotized or drugged by the company that he was exposed to whilst they were visiting Accused number 2. He was diagnosed with diabetes almost 21 years ago and receives medication and needs to inject himself on a daily basis. He is a first offender. He had pleaded not guilty and his version was rejected and was found guilty. According to him, he was implicated by some of the co-accused who already had testified. The police were under pressure to bring some people to justice. He believed that the investigating officer promised to assist the co-accused who had already pleaded guilty with a few years of or lighter sentences, and they should implicate the accused. He believes that he was framed and that someone had to be implicated in bringing some closure to a very public case. The media, according to him, has had a tremendous impact on the trial and has jeopardized their chances concerning a fair trial. The newspaper, magazine, and the writer has religiously been in court to provide feedback. They are seeking sensation and publicity to sell their stories at their personal expenses. He has maintained his innocence, and his only involvement with the co-accused was to pray for Accused number 2 and to assist her financially. He regrets that now more than anything else. The only remorse that he is able to express is that he got involved with Accused 2 in the first place. He did not express any remorse or insight. Vergeer said that direct imprisonment is applicable. Accused 2 did not testify in mitigation of sentence. She also called Vergeer, the previous witness in mitigation of sentence. She confirmed a report which was handed in as Exhibit 5U. The content of a report was read into the record, and it is also not necessary to repeat same in any great detail. It is evident from the report that a conflict exists between the facts obtained from Accused 2 and her parents specifically with regard to her upbringing and education, and most of the information that she had obtained could not be confirmed or verified. Accused 2 was born on 22nd December 1980 and is 38 years old. She has 2 children, a son who is 16 years old and is a grade 10 learner, and a daughter who is 12 years old and is a grade 7 learner. They both reside with their father, who is a former husband and has full custody over them. She got married to him during 2003 and was married for almost 15 years. They lived apart and separate lives and had separate bedrooms. She was arrested on 23rd July 2016. She was born in Harrismith and was raised in different areas and maintained a nomadic lifestyle. Her mother did not work and is a housewife. Her father was employed as an electrical inspector on the mines and is since retired. She was born in one family of 2 children. Her older sister was from her mother's first relationship. Accused 2 and her mother maintained different versions concerning her background and homely circumstances. Vergeer said that because of the contradictions concerning her family background and circumstances, the information received did not appear to be relevant, as almost all of it was either disputed or constantly amended by the concerned parties. She completed grade 9 at the Western Area High School and left school at the age of 15 years. Her previous husband is employed by the SAPS. Background circumstances could not be verified. She has been diagnosed with asthma since she was 16 years old and used an asthma pump and oxygen as required. Her medication is being provided for by her previous husband. She was diagnosed with epilepsy when she was 8 years old and uses prescribed medication. She has a bleeding ulcer and takes medication for cholesterol. She receives her medication in hospital, where there is a sister on duty who provides the medication. She has been detained for the past 3 years and was confirmed as a model inmate. She denied all involvement in Satanism. She is a first offender. She has pleaded not guilty and maintained her innocence. She said that she was implicated by some of the co-accused who had already testified. She has throughout maintained her innocence and has projected an unrealistic acceptance of her adverse circumstances. When pressured about her current own disposition, she became more emotional. Vergeer indicated to her that she could not write a report about her sins. It would or could possibly affect her negatively. She then said that, and I quote, "The judge should call upon God to come and testify if they are not content with her version." Close quotation. She clearly has no insight and no remorse and cannot express remorse for a case she did not commit or had any involvement in. She denied all involvement and stated that she was merely implicated by the witnesses so that they could benefit in receiving a lesser sentence. She has shown no insight and remorse. Accused 3 did not testify in mitigation of sentence. She called Hanali Skippers as her first witness, and Rosalind McNabb, who is a psychologist, who had prepared a forensic psychological report, as a second witness. McNabb's report was handed in as Exhibit 5Vs. It is not necessary to deal with their evidence and report in any great detail. Accused 3 was born on 21st October 1997. In respects of counts 2, 3, and 4, which took place on 4th and 11th July 2012, she was 14 years and 8 months old. She was 14 years and 9 months old when Bendixen was murdered on 13 August 2012. When Michaela was murdered on 4th October 2012, she was 14 years and 11 months old. During the commission of count 10, she was 15 years old. She was 18 years and 1 month old when the mayors were robbed and murdered on 27th November 2015. She was 18 years and 3 months old when Glenn McGregor was murdered on 26th January 2016. She was 18 years and 7 months old when Schofield, Mcalpin, and Latergan were murdered in May 2016. She was arrested on 23rd June 2016. She is the youngest child of Marinda and Andre Hugo. She has one sibling, namely LaRue Steyn. At the time of her arrest, she was residing at 1 Kosana Flats, Krugersdorp, which is the residence of accused number 2. After matriculating in 2015 with 6 distinctions at the Monument High School, she worked as a maths tutor at Jan de Klerk School, substituting for 1 full month in April 2016. Afterwards, she continued to tutor at the same school on a part-time basis, twice a week, consisting of 2-hour sessions. This continued until her arrest on 26 July 2016. She earned an amount of 4,000 rands for the full month, and thereafter 300 rands per session. Her parents got divorced when she was 4 years old. Initially, once her parents were divorced, she saw her father every second weekend and some holidays. From age 12 and during the relevant period, she had no contact with her father at all. After her father had made the decision not to see them in 2009, he made no effort to regain relations and exercise his rights to visitation with accused 3 or rekindle his relationship with her during the relevant time. He only visited her in prison after her arrest. Miranda made her move in with accused number 2 because accused 2 needed help when her husband was away. She had thought that it was a temporary arrangement, but was forced to live there permanently, which was against her will from the age of 13 years. She was exposed to accused number 2 from the age of 10 years. Prior to moving accused 3, and after losing all contact with her father, the only family that she knew was her mother and brother. She did not see her father because her mother had made her believe that he didn't want to see them. Her father had made a decision not to see him or to see them after the relationship between him and Miranda deteriorated to such an extent that he could no longer bear her controlling and possessive nature. Accused 2 and Miranda manipulated accused 3 and forbade any contact with any persons other than those they allowed, which essentially were all the accused, Miranda, LaRue, and accused 2's husband and children. She was not allowed friends, family, her father, and no longer attended church. She was repeatedly told that outside influences and contact with others would bring demons which were harmful to accused 2 and the children of the orphanage. She was repeatedly told that if she did not follow the instructions, that accused 2 would die and the children of the orphanage would be endangered. She was repeatedly told that the crimes committed were the will of God and that the money gained through the crimes was for the children of the orphanage. She was drawn into a cult-like situation from the age of 10 years. Miranda and accused 2 repeatedly threatened to kill her and LaRue if they did not do as they were instructed. She was present at the murders of Bendixen and Michaela and knew about the murders of Natasha and Joy. She had no doubt that she would be dealt with in the same manner should she not follow instructions. At the age of 15 years, accused 3 was given dogs to use by accused number 2 with the approval of Miranda. Although she has a high IQ and is extremely intelligent, psychological evaluation has revealed that she lacks emotional intelligence as a result of her delayed psychosocial development. She was described as immature because of her lack of exposure to normal relationships and a normal upbringing. She was exposed to Satanism and violent movies from the age of 10 years. After extensive psychological testing, it was found that she has no traits of being a psychopath. She has psychoactive substance abuse, bipolar disorder, without psychotic features, which are treatable, as well as avoidant personality features and obsessive-compulsive personality features, which are not problematic disorders and happen through environmental influence and which does not respond well to therapy. During the relevant times and between the ages of 12 to 18, which is an important psychosocial development stage for a child, her development was stunted due to the fact that she was not allowed to be independent of her family and adapt to society. Her development was hindered because of the dysfunctional family and the brutality to which she was exposed. She has shown remorse, which is evident in the fact that she had decided to come clean and tell the truth, which she did, regardless of the fact and what stage that was done. Her remorse was witnessed in court when she sobbed whilst relating what happened during Michaela's murder. Her remorse was evident when she addressed the families of the deceased in court. She was emotionally abused by Miranda. She has positive prospects of being rehabilitated and reintegrated into society. Psychotherapy will benefit her emotional difficulties. She will benefit from drug intervention and perhaps even religious counseling. She was under the age of 18 years in respect of some of the offenses and has no previous convictions. During the trial, I've also heard the testimonies from all the family members of the deceased persons about how their deaths had affected them. Their pain was palpable and genuine. Lorna Schroeder, the sister of McGregor, said that they are originally from Scotland, but have been residing in our country for many years. His death has emotionally affected their family, and they have kept his ashes pending the finalization of this case. She is on tranquilizers, antidepressants, but life must go forward. This case has opened so many wounds. Candace Ellison, the fiancée of Jared, had been dating him since 2011/2012, and in 2015, they were living in a shelter. They were both unemployed and were on drugs. On 16 December 2015, she was 8 months pregnant with his child. After he had not returned, she was very concerned because he never slept out. She was fed lies about his whereabouts by accused number 2. She had filed a missing persons report and was extremely distraught and could not understand what was going on. She was told by accused number 2 that Jared with his schizophrenia had perhaps left her and she should accept that. A daughter was born 3 weeks after Jared had disappeared. When she discovered what had happened to him, she was in a complete state of shock and had a breakdown. He had been excited about the fact that she was pregnant and that they were going to have a baby. She had a newborn baby without much support and completely lost all her trust and faith in humanity. Everything that she knew to be real, good and right disappeared. She was scared about what she was told. She had looked at everybody around her with suspicion and mistrusted them. She now has explained to her daughter, who is about 4 years old, who goes to school, and hear children talking about their mummies and daddies, and would ask her where her daddy is, and would say to her that her daddy is sleeping. This is not something that a little girl needs to know. She has one photo of Jared, and her daughter would take it off and climb on the bed and hug it, but has no clue who he is. Nina Scott Dawkins, who is the eldest daughter of the Meyer family, testified that her father had a dream of retiring and opening a holiday resort and a water park in KZN for his family. When she heard about the death of her parents, she was terrified and has thought about it many times. Nothing can justify how she feels, and she cannot explain it to anyone unless they've been through it. It is the worst loss that anyone can experience, and the fact that it was so brutal. They did not deserve that. It has affected her life, and they all had plans as a family to move to KZN, to get out of Johannesburg, to live a more peaceful life. And that has all changed, and it will never happen. Her 2 children will never know their grandparents, and her father loved the son, and he will not even remember his grandparents. Heather Schofield, the wife of Anthony Schofield, said that they'd been married for 47 years and has 3 children. They recently had a grandchild. She was her husband's personal assistant and had become worried after he had not returned from his appointment. After she was told about his death, it was absolutely traumatic for all of them, and she said that she cannot explain the pain and suffering, and also his pain and suffering that he must have gone through while he was being murdered. Her life has not been the same, and she's lonely, being all on her own. She had to retire alone, and she, her children and grandchildren will never get over his death. Kezia Mcalpin, who was 28 years old and was the wife of the deceased Kevin Mcalpin, said that they'd been married for 1 year and 3 days when he was murdered. She was 7 months pregnant with her first child. After he had not returned from his appointment on the day that he was murdered, she became worried, and her cousin and her husband had tried to keep her calm because of her pregnancy. After she'd been informed of his death, she felt her stomach pulling a little bit tight and was hospitalized for 3 days. The baby was born in August 2016. On the day before he was murdered, he had fetched her from homeschool and had told her that he was tired of the insurance industry because people's policies were lapsing and was looking for another steadier job and had sent out his CV. She later discovered that his life policy had lapsed and she had to give back her car to the bank. She had left work and was left with a baby and had to go back to work sooner than she had planned. It is difficult to raise a child on a teacher's salary, and she had to move out of the house they were staying in and is living with her mum. The deceased was her best friend, and they did everything together, and that was the reason why they just needed one car. They were both excited about becoming parents, and she had lost the opportunity to share everything with him. It is difficult for her because her little boy does not even know what a dad is, and all the things that the deceased had planned to do with him, he will never do. It is something that she struggles with all the time, and is so thankful for her little boy and does not know how she would have made it through without him. Linda Bendixen was married to Pastor Bendixen, who she said was partly retired, was doing itinerary ministry, was busy writing his manuscript, and was helping out Ria. He was 76 years old and was loved by so many people. His murder has affected her in many ways, and she's lost a special husband and best friend. She had to sell her house and has no pension and insurance. She sold her car to cover her expenses and put money in a trust. And if she retires, she will have a small pension to live off. She had to give away her animals. She is depressed and is lonely. And only people who've lost a spouse will understand what she went through. She is 69 years old and is nearing 70 and has to work. It is a financial burden. Andre Lattegan, the late husband of Johanna Lattegan, said that they'd been together for 34 years. They were divorced for a while and got together 3 months later and never remarried. 3 children were born out of their marriage. The impact of her death on his life was personally enormous. He never had depression, and for the past 2.5 years, he has been on antidepressants and medication for depression. He has tried to win it off, but it will only stop after this court case has been completed. His friend, his lover, and wife is gone, and he cannot explain it. He wakes up in the morning and thinks that this is the way his life is going to be for the rest of his life, and it is hell and not fun. One of his children was for some time in a psychiatric hospital. He has 3 grandchildren, one who was born a month after the incident, and that was something his wife had tremendously been looking forward to. His granddaughter, who is 5 years old, is still crying for her grandma, and she has now realized that she's never coming back. Amanda Achenbach is the niece of Joy, who was her mother's sister. She was 6 years old when she was murdered. The deceased was very close to her, and they had a special bond. She has lost a sister. Her mother died and was very depressed and had taken the death of her sister, the deceased, badly. Denise Berger, the mother of Natasha, said that Natasha had an LLB degree and had done her articles of clerkship. She was single with no children. And after the lighthouse incident, she said that she was not scared and was being protected by Jesus Christ. She was a precious child who was ripped away from her. She is depressed and cannot cope. It is still very painful for her. She had supported her financially, and her father is sick, and she was close to him, and her death has deeply affected him. He is stressed and now has cancer. Ilse van Dijk, the mother of Michaela Valentine, said that Michaela was married to accused 1 during 2000. She was working at Flight Center and was a student at the Rima Bible College when she got married. She would be given off on Thursdays to look after accused number 2. In August 2010, she called her and told her that she was going to leave her studies because, according to accused number 2, Rima was controlled by Satanists. There was a definite change in her, and there appeared to have been a darkness around her. She was talking a lot of rubbish that she was told by accused number 2. A week before she was murdered, Michaela came to see her on the Thursday and had asked for a lawyer, and she was scared. She had told her that she was going to leave the ministry, and she told Michaela that she had prayed for 3 years for that day to happen. She had said that there was something wrong there, and that people who had left the ministry were being killed. She was very confused and was crying a lot. She had been very gullible. They'd given a lot of money to the ministry. She saw her again on the Sunday before she was murdered, and she was beautiful, and there was a light again on her. On 4th October 2012, she received a call from accused 1's mother at about 16:30. She called her husband, who was sick in bed, and told him that Michaela had been murdered, and he got dressed and they went to where Michaela stayed. Accused 1 appeared to be absent-minded and unemotional, and it was very strange to her. After her body had been removed, she called him into the bathroom and had asked him to be honest with her and whether Michaela was a Satanist, and he had told her that she was not. Michaela had written many notes on a wall after she'd left the ministry. Accused 1 came to her funeral, accompanied by Miranda, and she was very upset about it. And it was something in her spirit that stood up, and she wanted to tell her that she was not welcome there. Accused 1 was unemotional at the funeral and did not speak there. A year later, she had sent accused 1 an email and had said that she was in a good place and had made a decision to forgive and set everybody free that were involved there, and had forgiven accused number 2, Miranda, Dries, and Jake de Villiers because she had believed that he and Greece were part of it. Accused one had responded to her email and had said that he was sorry that he did not look after Michaela and did not stop her murder and did not do more to stop it. When she heard that he was dead, she thought that they had killed him and was very traumatized and was going through the death of a daughter over and over again and was emotional and ended in hospital with heart palpitations, and it was very traumatic for her. When she realized that he was alive and that it was a scam, it was a very confusing time for her, and she tried to puzzle the pieces together. As a parent, they're not meant to lose their children in such a horrific way. Michaela's death has impacted the whole family life and the rest of their children. It is like your heart gets pulled out. Let me repeat. It is like your heart gets pulled out of your chest by force, and to think that there was somebody else that made the decision that the daughter's life was not worth it to live. And that was the most terrible thing for her. And if he had died in an accident or of natural causes, it would have been better. But to realize that somebody else made the decision to kill her in such a brutal way affected her very badly. To this day, it is not easy for her. But as a Christian, it is easier because she has forgiven. But it is an act of obedience to forgive. The heartache is still there, and the longing, and knowing that the child had that beautiful life in front of her, that she had entrusted to a beautiful young man's hand to care for her and to look after her, and then it was ended in such a brutal way. That was wrong, and Michaela was her eldest child. It was contended on behalf of accused number one that there are substantial and compelling circumstances present. He was 32 years old during the commission of the offences and is in possession of a BCom degree, which he had obtained from the University of the Northwest. He is a widower and is currently unemployed. Before he had lost his employment, he was employed as a financial advisor by Discovery. He later resigned and formed his own company, Deity Trading. He was misled and brainwashed by accused number two to believe that she was a former Satanist and that he'd given her about 2 million rands over a 4-year period after believing that there was an orphanage. He is a first offender and has a brother and parents. He was in custody since June 2016. He was manipulated by accused number two. He could not show any remorse because he is innocent. It was further contended that detention, his age, and all the factors that were listed by Vergeer in our report should be taken into account when considering an appropriate sentence. He had gained nothing from those crimes that he was convicted of, and he was not the manager of the enterprise, and the fact that he was brainwashed would constitute substantial and compelling circumstances. It was contended that in the light of the uniqueness of this matter, the defense could find no case law of similar nature and close facts that could be used as a guidance with regard to an appropriate sentence. The cases that were relied on are distinguishable from the facts of this matter. It was contended on behalf of accused number two that she is a 38-year female. She was married, but is now divorced and has 2 children, aged 15 and 13 years respectively. Her parents are alive, and she has an elder sister with whom she is close. She denied that she had taken part in any of the murders, and that she was a member of the Satanic Church, or that there is an orphanage that is looking after the orphans. She denied that she was a mastermind and had received any monies from the accused. She could not show any remorse because she maintained that she is innocent. She is a first offender and has been in custody for 3 years and 2 months. She is coping well within the prison environment. She has various medical conditions for which she was treated in prison and has been detained in the hospital section of the prison since her arrest and committal to the Johannesburg prison in June in 2016. It was contended that these would constitute substantial and compelling circumstances. The defense, however, conceded that the aggravating circumstances in the crimes committed by accused two far outweigh our personal circumstances. In those circumstances, retribution and deterrence come to the fore, and the personal circumstances reduced to the background. This court, so it was contended, is in a much more better position to decide on a suitable sentence as it evaluates all the evidence holistically. It was contended on behalf of accused number 3 that she was born on 21st October 1997 and is currently 21 years and 9 months old. At the commission of the first incident that she was convicted of, she was 14 years and 7 months old. For the 2 murders that she was convicted of in 2012, namely that of Bendixen and Michaela, the provisions of the CLA is not applicable. She was 18 years and 1 month old when she had committed the murders of the Meyer couple. With the McGregor murder, she was 18 years and 3 months old. And for the murders that she was convicted of in May 2016, she was 18 years old and 7 months. In 2016, she was a maths tutor at the school. She had passed matric with 6 distinctions in 2015. She was under the influence of her mother and Miranda, who had made her to believe that accused 3 was a Satanist and that the killings were justified in terms of the Old Testament. She was also manipulated by accused number 2. She grew up in a dysfunctional family. At some stage, she wanted to distance herself from the activities of the group, but after she was reminded what had happened to Michaela, she remained in the group and did what she was told. She had decided to come clean when she testified in court on 12 May 2019, after she had seen through the lies that Miranda and accused 2 had told her. She is single and is a first offender. She has shown remorse. Since she was compelled to do what she did, that should be a mitigating factor. Although she is highly intelligent, she is not emotionally intelligent. She was addicted to substance abuse. It was further contended that given the arbitrariness of the line drawn at 18 years, sentencing courts have to ensure that their sentencing decisions are not arbitrary. She has been in custody for a period of 3 years and 3 weeks. 3 years and 3 months since her arrest on 23rd July. Let me repeat that. She has been in custody for a period of 3 years and 3 weeks since her arrest on 23rd July 2016. And this is a factor that should be given due consideration for purposes of imposing sentence. She did not commit any of the offences which were direct intention, and the relevant form of intention is dolus eventualis. Her role in all the offences was considerably less than any of the perpetrators. She had testified in her defense and was an honest witness and told the court the truth regarding her involvement in all the offences. She had addressed the families of the deceased who were present in court and had expressed remorse for her part in the offences. Evidence was laid about the extent of the indoctrination when she was a child by accused number 2 and Miranda. The evidence of Rosalind McNabb should be accepted. She had provided an objective report and testified objectively concerning her findings after extensive psychological analysis and testing of accused number 3. Her report provides a valuable and insightful account giving reasons why accused 3 was in the position that she found herself. It was contended that if the personal circumstances of accused 3, the crimes committed, and the interests of society are considered cumulatively, substantial and compelling circumstances justifying the imposition of sentences less than those prescribed by the CLAA exist. It was contended on behalf of the state that there are no substantial and compelling circumstances that warrants a deviation from the prescribed minimum life imprisonment sentence for murder and 15 years imprisonment for robbery. Accused 1 had pleaded not guilty and proffered no plea explanation and had failed to put any version to the estate witnesses, save for a bare denial. When testifying, he came up with a conflicting version to the one he had provided at the bail application. He has shown no remorse in line with his version of a bare denial. He was at all times a mature adult male with above average intellect and a BCom degree. He had a stable upbringing and was one of the few privileged persons in this country to have had a wealthy and stable life until his involvement in the criminal enterprise. He has a lucrative and successful business as a financial advisor and was able to pay large amounts of money to accused number 2. None of the aforesaid individually or cumulatively constitute substantial and compelling circumstances. It was further contended by the state that accused 2 pleaded not guilty and proffered no plea explanation, and her version also amounted to a bare denial, with which she persisted throughout the trial. She has shown no remorse whatsoever, in line with the bare denial, and even made a shocking remark to the probation officer that the court must call God as a witness to attest to her innocence. She was a mastermind and at all times acted in a premeditated fashion, planning events to the minutest detail. She has failed to show the existence of any substantial compelling circumstances to justify a deviation from the prescribed minimum sentence. It was conceded by the state that in relation to accused number 3, in respect of the 2 murder counts that she was convicted of when she was 14 years old, that the provisions of the CLA would not be applicable. An appropriate sentence of 20 years would be appropriate for those murders. For the remainder of the charges that she was convicted of when she was 18 years and above, the minimum sentences would be applicable. There was a substantial hiatus in the criminal activities of about 30 months, during which she could have distanced herself from the group without fear of any reprisal. She had on her own applied to study at the University of Pretoria and was accepted. This is a clear indication that she no longer believed that accused 2 could read her mind or astral project to spy on her. After her 18th birthday, she participated in the mayor's murder. After she completed school, she lived the life of an adult, even acting as an after-substitute tutor in mathematics at her mother's school. This was a golden opportunity to get out of the spiderweb, but she did not. Her continued participation in the operations of the enterprise must be viewed in a serious light. She was no longer an innocent, immature youth anymore, but an 18-year-old who was seasoned in crime. What followed was not a single incident, but emanated from several incidents over a period of 6 months. All the crimes were well thought through, planned and executed with military precision. Her alleged fear or threat to remain part of the group was very vague and should not be relied upon. As part of the enterprise, she had a specific and important role to play during each incident, forming an essential participant for the successful execution of the offences. The extreme method of all the killings cannot be negated by a reliance on the background, cultism, or threats. The report fails to distinguish between the period before and after her 18th birthday, specifically with reference to the 6 murder and robbery counts committed after she had turned 18. She proclaimed to have shown remorse, but the evidence did not amount to an admission of guilt, but in fact a reliance on justification for her participation. It is not remorse in the true sense of the word. She has not shown remorse contrary to what McNabb said. She maintained throughout the proceedings that she was innocent. Her admission at a very late stage did not amount to an acceptance of any guilt, as she merely raised a ground of defense, being necessity. These crimes are so serious that it outweighs the personal circumstances of accused number 3. What counts against her is the fact that her criminal involvement was not limited to a single incident, but spanned from June 2012 to May 2016. She was actively and directly involved in the 8 murders and some of the robberies. Her about turn was purely tactical. After she had seen that the writing was on the wall and was done so to escape life imprisonment, her age is not a mitigating factor, and there are no substantial compelling circumstances that warrants a different sentence to life imprisonment in relation to the offences that were committed in 2015 and 2016 respectively. Life sentence does not rule out possible rehabilitation. In the absence of substantial compelling circumstances, the court is obliged and duty-bound to impose the prescribed minimum sentence. When dealing with heinous and barbaric offences, such as in the present matter, nothing less than the maximum suffices. In State v. Malgas, 2001, Volume 1, SACR 469, in brackets SCA, the sentencing courts were enjoined not to have regard to individual courts' views with regard to the efficacy of minimum sentences. It was stated that, firstly, the sentencing court was not to be given a clean slate on which to inscribe whatever sentence it thought fit. The sentencing court is required to approach the question of sentencing conscious of the fact that the legislature has ordained certain mandatory minimum sentences. Secondly, the legislature is now aimed at ensuring a severe, standardized, and consistent response from the courts to the commission of such crimes, unless there were and could be seen to be truly convincing reasons for a different purpose. Thirdly, the emphasis has now shifted to the objective gravity of the type of crime and the public's need for effective sanctions against it. Fourthly, this does not mean that all other considerations are to be ignored. Where there is a possibility of substantial and compelling circumstances, the central thrust of the focus on substantial and compelling circumstances is that sentences are not to be departed from lightly or for flimsy reasons, but a court must take into account the ultimate cumulative impact of all these circumstances, as previously have been taken into account. As was pointed out, that while each of a number of mitigating factors, when viewed in isolation, may have little persuasive force, their combined impact may be considerable. The test in deciding what constitutes substantial and compelling circumstances was dealt with in State v. PB, 2013, Volume 2, SACR 533 SCA, at paragraph 21 as follows, and I quote, "The most difficult question to answer is always, what are substantial and compelling circumstances? The term is so elastic that it can accommodate even the ordinary mitigating circumstances. All I'm prepared to say is that it involves a value judgment on the part of the sentencing court. I have, however, found the following definition, State v. Malchus above, at para 22, to be both illuminating and helpful. The greater the sense of unease a court feels about the imposition of a prescribed sentence, the greater its anxiety will be that it may be perpetrating an injustice. Once a court reaches a point where unease has hastened into a conviction that an injustice will be done, that can only be because it is satisfied that the circumstances of the particular case render the prescribed sentence unjust, or as some might prefer to put it, disproportionate to the crime, the criminal, and the legitimate needs of society. If it is a result of a consideration of circumstances, the court is entitled to characterize them as substantial and compelling, and such as to justify the imposition of a lesser sentence." Close quotation. The following was also said in the same case at para 10, and I quote, "In State v. Machichi, approximately 9 years after Malchus, this court noted that criminality is still on the rise in our country, despite the imposition of the minimum sentences, and has again stressed the relevance of the legislation as follows. Despite certain limited successes, there has been no real let-up in the crime pandemic that engulfs our country. The situation continues to be alarming. It follows that, to borrow from Malchus, it still is no longer business as usual." Close quotation. This is the worst case I've presided over in my 18 years on the bench. Words fail to describe what I'd witnessed for the duration of the trial. It was almost like I was listening to a horror story, except that in this case, the accused all professed to be Christians, and some even said that they were born-again Christians and had adopted the slogan Electus per Deus, which means chosen by God, and were responsible for all of this. They were all made to believe by accused number 2 that they were acting in terms of the Old Testament and that their deeds were biblical and were for a greater good. There was nothing godly about the deeds that they had committed. Psalm 23, which was recited by Peter Meyer when his wife was being killed in front of him, had no effect on them. They should perhaps have called themselves elected by Lucifer. The material spoils were small in the 6 murders that had taken place from November 2015 to May 2016. It was hardly worth the substantial loss and destruction in its wake, and the incidents were far apart with sufficient time, and one would have thought for pause and reflection. The murders, as stated earlier, were heinous and barbaric, that nothing less than the maximum penalty suffices. The only issue that arises in this matter is whether substantial and compelling circumstances have been shown to exist that warrants a different sentence to the minimum sentence that is prescribed in the CLAA. If I were to find that there are no substantial and compelling circumstances present, all the accused should be sentenced to life imprisonment for the racketeering and murder counts, and 15 years for the aggravated robbery, the one count of fraud, and firearms count. As stated earlier, the 2 murder counts that accused 3 was convicted of, which were committed in 2012, life imprisonment would not be applicable. Life imprisonment may also be imposed in terms of poker. None of the deaths were accidental. The victims were carefully identified and their murders were carefully planned and executed. All of the murders that the accused were convicted of were premeditated. The robberies were also carefully planned and executed, and all of the spoils were given to accused number 2, who was the mastermind in all of this. I simply do not understand how accused 1 and 3, bearing in mind that they are highly intelligent, could believe the utter rubbish that they were told by accused 2, that Natasha had to be murdered because she had allegedly prayed the wrong prayers, which led to the deaths of the orphans by the witches of the Satanic Church. This obviously is not true, since the orphanage only existed in the mind of accused number 2, and it was a figment of a sick and evil mind, and was used to get money from well-meaning people. Bendixen was murdered because he was Ria's mentor, and had allegedly used accused number 2's sermons without acknowledging her. Michaela, who had initially believed all the lies that she was fed by accused number 2, and had taken part in 3 of the murders, had seen the light and wanted to get out of the group, but was murdered to silence her and to prevent her from spilling the beans to the police. She had confided in her husband, who was regarded by Michaela's mother as a beautiful young man, and had entrusted her daughter to him when they got married. That beautiful young man turned out to be a monster and a ruthless murderer. Accused 3 took part in her murder because she feared that she would be ridiculed by accused number 2, who had told her that she had psychopathic demons. Peter and Joan were murdered because the group had believed that they were multimillionaires and they could get money from them. His recital of Psalm 23 did not stop his murderers. They only obtained 600 rands from them. Jared was murdered to allow accused 1 to fake his death and to claim a life policy worth 3.57 million, and had made accused number 2 his beneficiary. The remainder of the deceased, namely McGregor, Schofield, Mcalpin, and Latergan, were murdered because they were identified as wealthy people. All of the spoils, once again, were given to accused number 2. All of the meetings when the murders were planned and how they were to be executed took place at the One Kosana flat, which is a flat of accused number 2, and she was present. The report backs and debriefings took place at her flat. She was handed all the spoils of the murders and robberies of the six deceased persons, which came to a meager sum of 27,500 rands. Everything was done with approval. It was argued on behalf of accused 1 that he was brainwashed by accused 2, who had made him to believe there was an orphanage that existed. This version that he was brainwashed by her was not put to accused 2 when she testified. There were hints about that possibility to some of the witnesses when they testified, but it was never raised as a possible defense. The possible defense of brainwash may have been true when he was using his own money to spend on a non-existing orphanage. The brainwashing may have been around the existence of an orphanage and the supernatural powers that accused 2 supposedly had. I simply do not understand why accused 1 had arranged for his own wife, Michaela, to be killed when he had professed to be a reborn Christian or a born-again Christian. Michaela had seen through accused number 2 and had wanted out. He had told her that he was going to pray about it. But instead of praying with her, he betrayed that trust that she had in him. And he was told to lace her drinks with sleeping tablets. He was also accompanied to a funeral by Miranda, who was part of the group of persons who had killed her. He knew who her killers were, and Michaela's mother was very upset when she saw Miranda at the daughter's funeral. She could discern that there was something wrong about her being there. She had testified that a year later, she had sent accused one an email and had told him that she had forgiven the people who were responsible for the death of her daughter. He had responded to her that he felt responsible for her death and did not do anything to prevent her death. This would have been sent in October 2013, yet he did nothing about it and continued to be part of this murderous group which led to the killings of the Mayers and Jared Jackson. His belated claim that he felt guilty for not having looked after Michaela in his email to his mother-in-law, and after he went into hiding, was too late in the day. She had confided in him, which resulted in her murder. The same applies to the killing of Reggie Bendixen. He was a pastor who had nothing to do with the electus per deus. He was a man of God who was killed on the basis that he used sermons that were prepared by accused number 2. Natasha was murdered because she had read the wrong prayers, and because of that some children were killed by the witches of the Satanic Church. I would have expected that a person with a BCom degree who had been a financial advisor for a number of years and who had been a committed Christian and was raised in the Baptist Church would have known otherwise. He clearly is a highly intelligent person, and he alone knows why he had taken part in the killing sprees without questioning it. He had faked his own death and was part of an elaborate plan and scheme to have Jared murdered. The same applies to the murders of the Meyer couple and all the other murders that he had taken part in. He has shown absolutely no remorse and continued to tell lies to this court. He has not been candid with this court. His defense of being brainwashed is rejected. In any event, like I said earlier, he did not raise the defense of manipulation or brainwash or being hypnotized when he testified. His defense was that of bad denial and did not proffer any plea explanation, and had failed to put any version to the state witnesses, save for the bad denial. When he testified, he came up with a conflicting version to the one that he provided in his bail application. He was at all times a mature adult male with above average intellect and a BCom degree. He had a stable upbringing. He was one of the few privileged persons in our country to have had a wealthy and stable life until his involvement in the criminal enterprise. He had a lucrative and successful business as a financial advisor and was able to pay large amounts of money to accused number 2. None of the above-mentioned factors, individually or cumulatively, constitute substantial and compelling circumstances. When it comes to accused number 2, it is clear that there are no substantial and compelling circumstances present that would allow this court to impose a different sentence to the one that POCA and the CLA had ordained. Her age, health, and the fact that she is married with 2 children, and the length of time that she had been detained, does not support a version that there are substantial and compelling circumstances present in this case. She pleaded not guilty and proffered no plea explanation, and her version amounted to a bad denial, which she persisted with throughout the trial. Despite the fact that she passed grade 9, it is clear from the trial that she is a highly intelligent and streetwise woman and was able to deceive many highly qualified adult persons. She claimed to have had a normal childhood and participated actively in many different sport codes. She's currently divorced with 2 teenage children, a son and a girl. They are staying with their biological father, who is the de facto primary caregiver. She knew accused 1 from their childhood days. She has over-exaggerated a poor health condition, if regard is had to the evidence of Dr. Lowe. It is telling that she never had any asthma attack or required any medical assistance or oxygen during the trial. There is no indication that a medical condition cannot be effectively dealt with by the medical personnel at the correctional services. She has shown no remorse and even said to the probation officer that the court must call God as a witness to attest to her innocence. This remark is an indication of a dismissive, indifferent, and arrogant attitude towards this court. Accused 2 has made life hell for those that she did not get along with. She has destroyed the lives of LaRue Steyn, John Barnett, Brenda Steyn, accused 1 and 3, Michaela Valentine, Jake de Villiers, Ria Groenewald, and all the family members of the deceased. She had unleashed a reign of terror in the lives of so many good and caring people who had believed blindly what she told them. She had abused and misused the generosity shown by members of her group. Many of the state witnesses who came in contact with her and had to subsequently flee in order to survive her murderous plans. Many of them, like Ria, Arana, and Jake de Villiers, testified that they lost everything, to name but a few. Many other witnesses suffered emotional and psychological trauma, which required professional intervention. She was the mastermind and was the only person who had benefited from the spoils of the robberies. The motive for the first series of murders was revenge, based on a jealous relationship with Ria Groenewald. The motive for the second series of murders was motivated by personal greed and personal gain. She did not shy away from involving minors such as LaRue and accused 3 to give effect to her devious plans. She at all times acted in a premeditated fashion, planning events to the minutest detail. These plans included callous and cold-blooded murders of innocent law-abiding citizens. Only she knows what power and hold she had over them, and where that source of power came from. She is a thoroughly evil person who is incapable of any rehabilitation and is a danger to society and a person that she would meet with when she serves a sentence. I am extremely concerned about the people that she will be mingling with in the correctional centers where she will be serving a sentence. If she was able to manipulate a school teacher, a matriculant who had passed matric with 6 distinctions, and a person with a BCom degree, what more about people with no qualifications? It is clear from the evidence which has shown that her character is such that she should be removed from society permanently. She has failed to show the existence of any substantial and compelling circumstances in order to justify deviation from the prescribed minimum sentence. It was argued on behalf of accused number 3 that she was 14 years and 7 months old at the time when she became involved in some of the offences. During the course of the trial, she had seen that accused 2 had lied to her and had decided to come clean. The question that I'm grappling with is, what if what accused 2 had told her was true, namely that she was a 42nd generational witch, was a bride of Satan, there was an orphanage, that Natasha was praying the dangerous prayers, that Bendixen was using accused 2's prayers, whether she would still have proceeded with the murders and have continued to lie to court about her involvement or lack thereof. It's clear from her evidence that she testified that she had decided to come clean after she had learned that accused 2 had lied to them. The impression that I'm left with is that if there was an orphanage and Natasha was praying the wrong prayers, she would have proceeded by not having come clean to this court. She only decided to come clean due to the lies that she was told. Accused 3 was portrayed as this little innocent young girl who was misled by her elders in doing what she was told. It was argued that she was told that if she did not take part in those deeds, she would have ended up like Michaela. I find this to be somewhat strange, bearing in mind that Michaela was the 4th person who had been killed by this group. Natasha, Joy, and Bendixen had been killed before her. Accused 3 was part of the planning group of all 3 murders. She initially was part of the group that went to Natasha's premises on the pretext of looking for a cat and had a taser gun with her. She was part of the group that was supposed to kill Bendixen, but that mission was aborted after she had not felt well. She was present when he was eventually killed. She had wiped off the knives were jig after Natasha and Joy were killed. She went with her mother to Michaela when she was murdered and had also stabbed her. Her only concern was that her mother would have told accused 2 that she had frozen and she would have been ridiculed by her since she had those psychopathic demons in her. The issue of what had happened to Michaela could not have arisen at that point in time. It should also be borne in mind that after the murder of Michaela, there was a lull in the murders for about 2.5 years with no killings. She had argued that the group were planning to commit crimes during that period. That is not true, and it's not borne out by the transcript. She could not point out when exactly she was told that she would end up like Michaela. It is true that she was born on 21st October 1997. She had turned 14 on 21st October 2011. At the time when the first offences were committed, as from July 2012 up to just before Michaela was murdered, she was 14 years and 7 months old. She was 14 years and 11 months old when Michaela was murdered. With the murder of Bendixen, she was 14 years and 10 months. It's arguable that for the murders of Bendixen, count 8, which was on 13th August, let me repeat that. For the murders of Bendixen and Michaela, she obviously does not deserve to be sentenced to life imprisonment for that. And that in terms of Section 51(6), this court is prevented from imposing life imprisonment for those killings. It was argued that a defense of compulsion should serve as a mitigating factor, and I was referred to various judgments dealing with this defense, that it might be a mitigating factor. All the judgments that I was referred to are distinguishable, bearing in mind that the offences that the accused 3 was found guilty of were not spur-of-the-moment events, but it rather involved pre-planning meetings where the pros and cons were discussed, and she was a willing participant. What should also be borne in mind was that there was a lull of the period that I'd mentioned to earlier. And when the Meyer couple were killed, she was already an adult. So the arguments raised in respect of the 2012 murders do not apply to those when she was 18 years and above. The next murders that she was convicted of were on 27th November 2015, when she was 18 years and 11 months old. She was no longer a child. She was in matric. The next murder that took place on 26 January 2016 was when she was 18 years and 3 months old. Then she was no longer at school. The remaining murders took place when she was 18 years and 7 months old. I am not persuaded that for the murders that she had taken part in after she had turned 18, that it can be argued that there were substantial and compelling circumstances present. I want to point out further that she had testified that she could not understand why they had to murder the Meyer couple. She did not accompany the group when they went to kill Jared Jackson. She went on her own accord when McGregor was killed. She had decided on her own to accompany Marinda and John Barnett when they went to dump the body of Hanali Lottegan. This was after LaRue and Marinda had a fight, and after LaRue had said that it was the first time that he had killed a woman. Has accused number 3 shown any genuine remorse for the crimes that she had been convicted of? It is common cause that accused 3 had pleaded not guilty and had decided to come clean when she testified in court towards the end of the matter. Evidence was led that LaRue and his father had asked her to confess her crimes, and she was invited also to do so by the police and had refused to do so. The absence of remorse impacts negatively on the consideration of rehabilitation, as there is no factual basis for a finding that there is true remorse if an accused does not step out to say what is going on in her inner self. Although accused number 3 opened up her heart at a very late stage of the trial, she still maintained her innocence by relying on the defense of necessity. She's now contending that she feared that she would be belittled or ridiculed with a vague reference to the fate of what had befallen Michaela. She was initially part of the plan devised between her mother, accused 2, and herself to mislead the court by telling Marinda to plead guilty and to take the fall, so to speak, for all the crimes and exonerate accused number 2 and 3 from being involved whatsoever. The approach to be adopted when considering the issue of remorse has been set within a number of cases. For example, State v. Martin, 1996, Volume 1, SACR, W, at 177H2I. The following was said, and I quote, "The plea does not necessarily imply anything more than that the accused is realistic. For purpose of sentence, there is a chasm between regret and remorse. The former has no necessarily implication of anything more than simply being sorry that you've committed the deed, perhaps with no deeper roots than the current adverse consequences for yourself. Remorse connotes a repentance, an inner sorrow inspired by another's plight or by a feeling of guilt, for example, because of breaking the commands of the higher authority. There's no factual basis for finding that there is true remorse of the accused, if the accused does not step out to say what is going on in the inner self," close quotations. The following was said in State v. Peters, 2001, JDR 0857, in brackets ECM, at pages 3 to 4, and I quote, "It cannot be correct, however, that a mere plea of guilty constitutes an element of remorse. The accused must go further than merely tender a plea of guilty. The elements of remorse must be inferred from the surrounding circumstances of the plea itself, like spilling the beans and confessing his guilt, making good the damages he has caused to the complainant, and handing himself over to the police. The plea of guilty must show genuine penitence on his part. This view is fortified by Ponan J.A. in State v. Machichi, in which he said the following: "Remorse was said to be manifested in him pleading guilty and apologizing through his counsel, who did so on behalf from the bar to both Mrs. K.D. and Mr. C. It has been held quite correctly that a plea of guilty in the face of open and shut case against an accused is a neutral factor. The evidence linking the respondent to the crimes was overwhelming. Remorse is a gnawing pain of conscience for the plight of another. Thus, genuine contrition can only come from an apprehension and acknowledgement of the extent of one's error. Whether the offender is sincerely remorseful and is not simply feeling sorry for himself or herself at having been caught is a factual question. It is to the surrounding actions of the accused rather than what he says in court that one should look at. In order for the remorse to be valid, in order for the remorse to be a valid consideration, the penitence must be sincere and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. After all, before a court can find that an accused person is guilty, is genuinely remorseful, it needs to have an appreciation of inter alia. What motivated the accused to commit the deed? What has since provoked his or her change of heart? And whether he or she indeed have a true appreciation of the consequences of those actions. All these factors are peculiarly within the knowledge of the respondent in casu, who knowingly withheld them from the court, a quo, for it to explore his allegation of remorse. Because he has not given evidence, the court still remains oblivious of his motive to commit the offence and what caused his subsequent change of heart. The documentary evidence provided conclusive proof of his guilt beyond a reasonable doubt, thus closing every escape route for him. In my view, the plea of guilty in the circumstances of his case, does not constitute an element of remorse, and the magistrate, with respect, misdirected herself in finding that it does. Close quotation. The evidence against accused number 3 was overwhelming. There was a formidable and unshakable case against her in the light of the evidence of LaRue, Barnett, and de Villiers. Her belated change of heart was motivated by the inescapable conclusion of her guilt, was merely a ploy to provoke sympathy. She took a chance